Good morning. I'm Brianna Nadeau, council member for Ward 1 and chair of the council's Committee on Public Works and Operations. Today is Thursday, May 22nd, and I'm calling to order this roundtable of the Committee on Public Works and Operations. The time is 10:02 a.m. Today, we will discuss consumer protection procedures in the District of Columbia. The Consumer Protection Procedures Act, or CPPA, is the district's law to protect consumers from unfair and deceptive business practices. The council first passed the law in 1976, and there have been several updates over the past few decades as business practices have evolved. The law is enforced by both the Department of Licensing and Consumer Protection and the Office of the Attorney General. Earlier this year, I introduced Bill 26-174, the Enhancing Consumer Protection Procedures Amendment Act of 2025, along with Chairman Mendelson, to make important updates to the CPPA to expand consumer protections. An earlier version of a similar bill was introduced by Councilmember Pinto in 2022, after which a consumer protection working group consisting of council staff, the Office of the Attorney General, the Department of Licensing and Consumer Protection, and other relevant stakeholders met to develop recommended revisions, which are incorporated into the introduced version. This legislation will make critical updates to ensure the district's enforcement agencies have the tools necessary to enforce these protections, including granting OAG authority to interrogatories, subpoenas, and other investigation and enforcement powers in consumer protection investigations, clarifying that charitable solicitations are subject to consumer protection laws, prohibiting retaliation against consumers who report violations, and increasing fines for violations. Today, we're joined by Adam Teitelbaum, who is the Director of Consumer Protection at the DC Office of the Attorney General, and will discuss the portions of the bill that relate to OAG's enforcement. During Mr. Teitelbaum's time with OAG, he has overseen several high-profile consumer protection case wins and was instrumental in the development of this legislation. The committee will hold a public hearing on the bill at a later date when other relevant agencies, stakeholders, and public witnesses will have a chance to weigh in. Now we will hear from our government witness, Mr. Teitelbaum, but before you begin your testimony, I will administer an oath to you. If you could raise your right hand, please. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
Wonderful. You may begin when you're ready.
Thank you, council member. And before I dive into the formal testimony, I just want to personally thank you and your staff for making this roundtable happen and for giving me this opportunity to support this important bill. As you noted at the outset, this has been a long-running process, and we had a really great, productive, robust working group that I think came to a really great result. I'm so happy to support that and to answer questions about it. And again, just personally, thank you for helping move this bill forward. So with that, I will say good morning to you, to residents of the district. Again, my name is Adam Teitelbaum. I'm the Director of the Office of Consumer Protection at the Office of the Attorney General for the District of Columbia, or OAG. And I'm here to express OAG's strong support for this bill, Bill 26-174, which will modernize, strengthen, and clarify the district's consumer protection laws to ensure that they continue to provide robust protections for district residents, lay out clear rules for the benefit of district consumers and businesses, and allow for efficient and effective enforcement. So OAG enforces the Consumer Protection Procedures Act, or the CPPA, to protect consumers from a wide variety of bad business practices in all industries across the district. And that includes deceptive and unfair practices, violations of tenant rights and civil rights, and conduct that harms the environment. Since 2023 alone, OAG has secured judgments totaling nearly $80 million through its enforcement of the CPPA. And that figure, importantly, includes restitution back into consumers' pockets, which is what we prioritize, as well as penalties and remediation funds. But beyond those numbers, these cases often have real-world, sometimes life-changing impacts on behalf of district residents. From, for example, permanently shutting down a fraudulent recruitment scheme that preyed on foreign exchange teachers and putting money back in those victims' pockets, to combating predatory lending practices that often trap district consumers in cycles of debt, to obtaining tens of millions of dollars that will go directly toward remediating the opioid and the youth vaping epidemics. Now, although the CPPA remains a very powerful tool, it is long overdue for a comprehensive update, which is exactly what this bill would provide. Over the past decade, since the last time we had another sort of major round of CPPA amendments, OAG, along with other practitioners and other enforcers, have identified areas of the law that require clarification and that require modernization, informed by issues that we've faced in our enforcement actions and that others have faced in actual litigation. And as you noted, these bills provisions were drafted by a working group that included relevant DC agencies, legal service providers, other practitioners, and key stakeholders, leading to full consensus on the bill's core provisions. These provisions will provide clear rules of the road for consumers and businesses alike, and they will allow for fairer, more efficient, and more effective CPPA enforcement. I'm happy to answer questions about any of the bill's many provisions, though in this testimony, I don't plan to go through them in detail. I thought it would be more helpful to highlight some illustrative examples to show the real-world problems that these amendments were designed to help solve. And they fall into three general categories. First, the bill modernizes and strengthens the CPPA by filling important gaps. To take one example, the CPPA or the bill would expand the CPPA to cover charitable solicitations, which would ensure that people and businesses seeking donations cannot deceive or take advantage of potential donors by, for example, lying about what the money will be used for. This closes an important loophole, as current law does not provide meaningful protections against deceptive charitable solicitations. The bill also strengthens the CPPA by including new prohibitions drawn from the Federal Consumer Financial Protection Act that bar abusive conduct, business practices that take advantage of consumers' lack of knowledge or understanding of the transaction. This is in line with a recent trend in state consumer protection laws that have adopted similar provisions. The second category of changes is that the bill would clarify the CPPA in various ways to avoid burdensome and unnecessary litigation and to provide clear guidance to businesses and the public. For example, the bill would make clear that businesses that supply goods and services are included in the definition of merchant, regardless of whether there is a formal exchange of money. This ensures that businesses that provide purportedly free services, such as social media companies, cannot engage in deceptive business practices, and it will avoid the need for parties to litigate this issue over and over again. Similar concerns prompted other clarifying provisions of the bill, including those that would make clear that unlawful transactions are covered by the CPPA and that lay out the appropriate burden of proof under the CPPA. Further clarity on these points will save time and resources for enforcers, plaintiffs, and defendants. And third, the bill gives enforcers like OAG and the Department of Licensing and Consumer Protection, or DLCP, additional tools and remedies to ensure for more efficient investigation, greater deterrence, and meaningful relief for consumers. For example, the bill prohibits businesses from retaliating against consumers who complain to OAG or to DLCP about bad business practices, or who assist our agencies in moving a matter forward in enforcement or an investigation. This will help ensure that consumers feel safe and protected when they come forward and when they share their experiences with us and cooperate in our investigations, all of which is essential for effective enforcement. The bill also authorizes OAG to require subjects of consumer protection and financial exploitation investigations to answer written questions under oath during an investigation, which will allow us to quickly obtain the information necessary either to conclude an investigation that does not warrant further action or to speed up those that require enforcement. In addition, the bill would make clear that in appropriate cases brought by OAG, a court may order remedies designed to prevent additional harms to consumers, such as enjoining a company from engaging in certain practices, freezing the company's assets, placing it in receivership, or in appropriate circumstances, dissolving the company. This would align the CPPA with the remedies already permitted under the Nonprofit Corporation Act and the Tenant Receivership Act. In addition, the bill grants DLCP important administrative tools, ensuring that it can nimbly address CPPA violations through, for example, strengthened cease and desist powers. This is an important complement to OAG's litigation authority, which is not well suited to addressing one-off problems or those needing a very quick resolution. In short, while no single provision in this bill is a magic bullet to end harmful business practices, these amendments, when taken collectively, will fill important gaps and ensure that agencies like OAG and DLCP can do more with less. OAG stands ready to build upon its history of protecting the public from those who take advantage of them. And I thank you and welcome any questions you have.
Thank you very much for your testimony. We will dive right in. I want to start with a few background questions on OAG's current enforcement of the CPPA and the consumer protection work. Can you describe OAG's current role in enforcing the Consumer Protection Procedures Act?
Sure, I'm happy to do that. And the way we think about it is we have sort of two streams or buckets in how we tackle problems under the CPPA that we become aware of. Most of our work and where we focus most of our resources is toward what we'd call formal enforcement. So that includes formally opening up a pre-suit investigation. Through that investigation, gathering the facts we need to understand what the scope of the problem was and if there are violations. We do that through subpoenas. We do that through other informal means. And then if necessary, taking formal enforcement action, which would be filing a civil lawsuit in Superior Court to seek all the remedies that we in the public are entitled to for violations of the law. And that includes, as I mentioned, restitution, which is money back in consumers' pockets, injunctive relief, which is changing the business practices so that they're no longer problematic, and then penalties, which is an additional deterrent to bad business practices. The reality, though, is in terms of resources, we cannot take formal enforcement action for any more than a fraction of the actual CPPA issues addressing district consumers. So in light of that, we funnel those enforcement resources all with an eye toward where can we have the greatest impact on behalf of the most number of and the most meaningful impact on behalf of DC consumers, while also hopefully having a deterrent effect to change practices across the district, across industries, even where we don't bring a case against a particular actor. So that's sort of the main bucket. Recognizing that there are all sorts of other issues and complaints that come in, sometimes on a one-off basis, that do not rise to that level where it makes sense to devote enforcement resources. We have a mediation program that we've developed and in recent years really bulked up so that we can be responsive to all of the other complaints that come in from district consumers. So that mediation program is supervised by an attorney, but it is largely staffed by professional staff, paralegals, investigators who are trained to do these, what we call informal mediations. So every district consumer that comes to us with an issue that is within the scope of the CPPA, we will mediate. We will take that complaint, work with the business through a voluntary process to try to reach a resolution for that consumer. I think last year we had about 10,000 complaints come in through some means. We have an online portal, we have an email inbox, we have a hotline. And for many of those complaints, we're able to achieve results. I think last year alone, we brought $1.2 million back into district consumers' pockets. And a lot of that is like $5, $25 refund here and there. And so while that is and for mediations that we cannot successfully resolve, we can refer out to other appropriate actors like DLCP or give them other referrals of where they can seek private attorneys to help them address their concerns. On top of that, on the enforcement side, the formal enforcement side, we also monitor all those complaints looking for trends, and often we'll see something more widespread that then rises to the level of formal enforcement. So that's sort of long-winded, big picture view of how we sort of address all sorts of problems through those two buckets.
How often do the bad actors actually participate in the mediation?
The vast majority of the time.
So
And I think, and we're not the only AG office that does this. Most state attorney general's offices have some form of a mediation program that works almost just like this. And I think the reason there's participation is because while it is a purely voluntary process, they understand that when our office is monitoring these complaints and looking for widespread issues. So they often have have an incentive to, where they've done something wrong, to make the consumer whole. And actually, more than anything, what our involvement does is it makes sure that the business is actually responsive. So time and time again, people come to us when they've been given the runaround by the business, either not responding for months or sending them back and forth between departments. And our involvement sort of helps bring things to a head so the right people are talking to the right people. And so that oftentimes it's something that maybe would be resolved without our involvement, but we're able to make it just happen usually a whole lot more quickly. But when I say it's voluntary, it's voluntary. It is common for businesses in certain areas. Construction fraud is sort of an area where it's rare that the wrongdoer engages. And so that in some areas, it's not a great tool.
Yeah.
But in others, it can be very effective.
That's the one I get the most complaints about. That's why I was asking.
Yeah.
So, what is the division between DLCP and OAG in enforcement?
So as I mentioned in my testimony, we really do view it as a very complementary role. And again, it is often like in other states, there's a similar, the Attorney General handles litigation and formal enforcement for consumer protection matters. And then there's usually an administrative agency that has different administrative remedies. And I think it works well because while our enforcement tools are very powerful, they are often not as, they rely on the litigation process, which is often slow. And so while it can be very effective for widespread issues to get, widespread relief, it is not a good tool for something that needs to usually happen either fast, or if it's sort of a one-off issue that is problematic, but not affecting a large number of district consumers. So for example, DLCP has the ability to issue notices of infraction very quickly. It's through this bill seeking to have more powerful cease and desist authority. So if there is a business, for example, doing, that doesn't have the proper license to sell or do the good or service that it's offering, that's something where DLCP can be very nimble and go in immediately, where it just, licensing issues is a good example of something that fits very well into DLCP's wheelhouse, and that it just doesn't make sense for us to vote attorneys to play the whack-a-mole with businesses and spend a years-long litigation over an unlicensed business. And there are other things that are more well-suited to, they have investigators that can do, many more investigators that can do in-person enforcement. So things like enforcing the district's vaping laws, the flavor ban, where there's a brick and mortar corner store that may be violating. Unless it's a large business or chain, it's probably not something that makes sense for us to devote our enforcement resources. That is a great area where DLCP steps in. And we have, I think, bi-monthly coordination meetings where we talk about where each of us has sort of our lane where we think we can be most effective. And all of the time we're referring things to each other, even between those bi-monthly meetings, that fit more in one or other wheelhouse. So through our mediation program, things come in where we know, for example, DLCP has a funeral board that oversees deception and issues in the funeral industry, which can be a very problematic. There are many problems in that industry. Because they have all of that expertise, it makes sense for us to forward those things their way. And there are other categories like that.
And does OAG investigate all the complaints you receive?
So the short answer is no, for the resource reasons I mentioned. We do, though, mediate every single complaint that comes in that falls within our jurisdiction. So long as it is a consumer protection issue that affects, that involves a DC transaction, either a business in DC or a DC resident, we will mediate it. And if that is unsuccessful, if the business doesn't engage, we will make sure that we give them all the referral resources they can to take action on their own or to go to another agency. But as I mentioned, for our formal enforcement, we are really looking at where can we make the greatest impact? And it's really those issues that hit those more widespread issues that we formally investigate.
On an annual basis, how many complaints does OAG typically pursue via legal action or formal action?
So via formal action, well, let me answer it this way. At any given time, we usually have about 60 to 75 active matters. And that is usually a combination of formal investigations as well as actions that are in active litigation.
Okay.
And the majority of those are investigations. I think currently we have somewhere between 10 and 15 active litigation matters. And these matters, as I mentioned, sometimes last year's, probably in any given year, we open up another 10 to 20 investigation matters.
Thank you. You mentioned the DLCP will sometimes refer cases to OAG. What types of cases are those?
Usually, they're usually the types of cases where they are seeing widespread issues, where they're seeing issues that are affecting, dozens, hundreds of district consumers. That is often a subject of conversation on our bi-monthly meetings. They'll mention patterns or trends that they're seeing, as well as there are certain types of issues that are more, the deception may be more complex. That is something that they wouldn't typically handle. So for example, we often are tackling issues with complex purchasing transactions online or through applications. That is usually not the sort of bread and butter CPPA violations that DLCP would handle, and they will refer those things our way.
And what are the most common types of complaints that you're dealing with?
So through our formal enforcement or through what we see in our mediation program?
Both.
Or I can answer both.
Yeah.
So mediation program, so the CPPA also covers landlord-tenant transactions. So that is a large chunk of what comes in through mediation. So that could be housing conditions issues. That could be utilities issues that we especially recently have heard a lot about.
Mm-hmm.
Other landlord-tenant deception. Restaurant fees is a large number that comes through our mediation program. Issues with social media platforms, including like Facebook lockouts. If you ask any state AG office, that's a huge category of what comes in, which is people who get locked out of their Facebook accounts, believe it or not, usually elderly folks. Construction fraud and home repair, as you mentioned, financial scams. Those categories probably take up the majority of what comes in through our mediation program, retail fraud, retail issues. In terms of what we choose to prioritize for our formal enforcement, as I mentioned, we're always focused on what is going to have the greatest DC impact. That ends up being a mix of more hyperlocal cases as well as national cases that have a real negative impact on DC consumers. And we also, in choosing what to prioritize, have a big emphasis on, is there a vulnerable population being taken advantage of, folks that may be least able to advocate on behalf of themselves. So what our docket ends up looking like is a mix, in part because we try to cover the field across industries. We do a lot in predatory lending, as I mentioned. We focused in part because AG Schwab has a focus on issues impacting kids. We have a number of cases in the youth vaping context, our social media cases, the impact they have on teen mental health. And then we have, fraudulent recruitment schemes that impact DC residents. We brought cases for tax preparation, fraud, and issues affecting vulnerable DC populations. We do privacy work, deceptive fees. We really try to sort of run the gamut, but the North Star always is, where can we have the greatest impact? And also, where can we fill gaps where either other enforcers or for other reasons, private attorneys don't have the incentive to address an issue? That's where we're looking to, where can we have our greatest and highest impact? those are all the sorts of things we're thinking about when we choose what to prioritize. And I mentioned the mediation program and DLCP as a key source for referrals, but a huge part of our work is just getting information about what is the field of issues affecting DC consumers. So we invest a lot of time and resources in building pipelines with legal services providers, other community organizations, so that people know to bring those issues to us, so that we have, a strong as understanding as we can of what are the issues affecting DC residents.
Can you say more on two things? One is the way you pursue utility issues and the way that you pursue restaurant fees?
Yes. Starting utility issues is tough. Under the CPPA, we are able to go after deceptive fees. So fees where they're not properly disclosed to consumers, or where the purpose of the fee is not adequately disclosed. That is sort of our only hook for going after utility issues, which I will just say, I don't think is a strong enough hook to really go after the whole of the problem, which is probably more of a policy or a legislative issue, because there's nothing in current law that requires a certain method of calculating utility fees. So I know RUBS is a huge issue, is a way of multifamily units to sort of divvy up utility bills, sort of how they're calculated, so long as that calculation is properly disclosed, is not necessarily a CPPA issue. But what we have tried to do through our mediation program is to, when we get complaints, to work with the buildings to make sure that the tenants have the right amount of transparency to how their bills are being calculated. And where there is not that adequate transparency, it is something that could rise to the level of formal enforcement.
What about the third-party utility predator folks that go door to door and promise certain rates and then jack them up?
That would be a CPPA issue depending on the facts.
Okay.
And I want to be careful of what we can sort of disclose publicly in terms of our confidential investigation work, but it is an issue that is on our radar and we recognize as one that's impacting DC residents.
Let me know if you need any witnesses or
excellent
claimants or whatever. Okay. And I interrupted you, but on restaurant fees.
So we, you may recall a couple of summers ago, we issued guidance to the restaurant community, in part because we did see a widespread issue in terms of how fees were disclosed and whether people were being surprised on their bills about particularly service fees and other different labels were put on them, different fees that popped up on people's bills. And we, again, consistent with the limits of what the CPPA requires, which in our view, the CPPA doesn't mandate you can or can't charge certain things to consumers. It is about transparency and adequate disclosure. And so the guidance focused on making sure people know upfront in a very clear manner what sort of fees they may be charged before they order, and making sure that what those fees are going toward, in particular, whether they're going to directly, like tips on top of wages to staff, whether they're just going to sort of the restaurant's bottom line, or going to going just to the underlying wages, that all of that has to be clearly disclosed to consumers so that they understand what they're paying for, so that they can make informed decisions about where to dine, whether to tip on top of that, et cetera. You may recall after that guidance, council then passed a separate bill that had in some ways mirrored our guidance, but had more specific sort of details about how that should be disclosed, but did ultimately sort of sanction or allow restaurants to charge service fees up to a certain amount. I think it was 22%. I mean, it may be 20%. It's one of those two numbers. We continue to monitor whether that is being complied with. We have been doing what we would call sort of soft enforcement, which is where we see issues. We have been reaching out to restaurants, and to date, all restaurants have fixed those issues. But we continue to invite, and we have been inviting the community and others to send us those complaints. We've frankly not gotten many of them since this really all came to a head about a year and a half, 2 years ago. But we continue to ensure that that guidance and ultimately that law that was passed gets complied with. Others still, I think there was a paper article recently, have real concerns about service fees and whether they're appropriate at all. From our view, under current law, our role really is just making sure that there is transparency.
Thank you. Councilmember Allen introduced a bill to prohibit buildings charging additional fees for common space utility charges in rental buildings. Is this something you all have dealt with that the CPPA could apply to?
Yes, so that's the RUBS issue I mentioned,
Oh,
is sort of
okay.
how these multifamily units address or how they essentially divvy up utility bills among the residents. And so one way of doing it is through sort of formulas. One way to do it is individual metering on individual units. One way to do it is sort of a formula to take the overall bill and based on how many tenants there are in the unit, what the square footage is, divvying it up. But one issue has been, should those consumers be charged for common spaces? And if so, how they are charged for that? Again, under current law, our view is there just needs to be transparency to consumers about how that's charged. I've not yet taken a close look at that bill, but I think the bill would provide more clarity about actually how common spaces, utility charges related to common spaces can be charged to tenants.
Yeah, the thing that I think we need to consider with that legislation as it's moving forward too is this just a backdoor way of raising rent beyond what's allowable in certain buildings, right?
Yeah.
Oh, it's not rent, it's a common area fee. We have one building in Ward 1 where they just started charging $50 a month for the Wi-Fi in the lobby for every tenant. I mean, there's no way that's what it costs the building management company.
And that is a great point. And that is something that would be concerning even under the CPPA. So I mentioned that sort of transparency as to what they're going to be charged is one element, but also transparency about what they're being charged for is something that the CPPA covers and something that we have taken a look at, including in this context, and have concerns about. Because you're right, even if people know upfront they're paying the $50, if they're saying it's for Wi-Fi, but it's not really for Wi-Fi, that could be a CPPA issue as well.
All right, we'll follow up on that one. And walk me through what's the typical process when OAG receives a complaint in this framework?
So it really is only the mediation program that has sort of a complaint-based system. So the enforcement work, while we monitor complaints, there is not a typical process. We are looking at the whole range of issues that we learn from mediation, from investigative reporting, from referrals from other agencies. And if we choose to take action, typically step one is reaching out directly to the business, often through a subpoena, sometimes through an informal letter to start to gather the information we need to suss out, is this a problem? What is the problem? And then ultimately those formal investigations go one of two ways. One is, it's not uncommon that we will close them out. We either satisfied that what we thought was a concern based on the information we see isn't a concern, or it's not of such a level that formal enforcement is appropriate. The other level is we need to resolve this. We try to resolve it pre-suit if we can. We'll almost always try to engage the company in pre-suit settlement discussions. But if that's not successful, we then resolve through litigation. Also, it is common that through some amount of litigation, at some point, the company comes to the table and we're able to resolve it. But if necessary, we will litigate the case through trial. That's the enforcement side. On the mediation side, we have a pretty robust process, which involves, as I mentioned, responding to every single consumer complaint if it's within our jurisdiction. I think our current guidelines is we try to respond within 5 business days. Although for priority complaints, including like loss of heat during winter or AC or other really serious conditions issues, we respond day of. And we start by gathering information from the consumer. And then our role throughout the process is essentially we are the intermediary between the consumer and the business. We convey the consumer's issue and desired resolution to the business. We require the business to respond within a certain number of time. We then convey the response. And through that back and forth, hopefully reach some sort of resolution. Although, as I mentioned in the sort of more serious health and safety issues, we're doing that on the phone, usually in real time day of. And often quite successful in, and usually coordinating, for example, with DOB or other agencies to try to get those situations resolved immediately. But for a non-health safety issue, we try to resolve those issues within a matter of weeks and maybe a couple of months at most. And we try not to let them drag on for many months or beyond that.
Would you be able to say about how long it takes for OAG to decide whether you're going to be going through informal or formal?
It's a hard question to answer because we're not looking at every single complaint and making that decision. Just because of we're getting dozens, if not sometimes hundreds in a week. We just don't look at every single complaint and decide which track it's on. More so what we do is we meet regularly with our staff who runs the mediation, who manage the mediation program, and they identify issues and patterns for us to take a look at. And then it often depends on capacity. So if we have the resources we can take on a couple of more investigations, we will then go and we frankly have what we call like a back burner list of these are issues that when we have the time and resources, we will look into. But of course, things come in that we recognize are more time sensitive and we make the time and resources to handle them more quickly. That's happened in issues where there's like ongoing deception. There was a case a couple of years ago where a company was deceptively sending letters out to all district residents saying they were overdue on their property taxes and trying to get them to sell their homes at below market rates to them immediately. We knew, especially because a lot of elderly homeowners were being targeted, we need to go into court immediately and get immediate relief, which is what we did there. But for issues that are not as time sensitive, we are just sort of monitoring. And when we have capacity, we will take on another matter for investigation.
Got it. So like this issue transpired, it's no longer happening. I'd like a resolution, and then you guys can get to it when you have the time because you want to help them with restitution, but it's already occurred.
Right.
Okay.
So in other words, most of the remedies we're able to get are backwards facing, sort of remediating past harm. And so those are going to be less time sensitive than ones that come to our attention that, okay, the harm is either ongoing or it's about to happen, that we may have different calculations about the timing of when we choose to prioritize those.
What are some of the biggest barriers that your office faces when pursuing consumer protection cases?
Number one is resources. It's always resources. We have about, I think, 12 or 13 attorneys doing consumer protection work, another roughly 10 professional staff. We could have 10 times that amount and still be doing really impactful, meaningful work. We also know that that's unrealistic. So part of what this bill is designed to do truly is to allow us to do more with the same amount of resources. Because a lot of these, for example, clarifications are issues that frankly have been weaponized by bad actors to delay cases, often by months. So if we can shortcut those delays, that is more new cases we can be opening. And then some of these tools allow us to sort of get to the heart of an issue quicker, like the pre-suit interrogatories, which is forcing a company to answer questions quickly without us having to gather thousands of documents to find those answers. That allows us to move our investigations forward more quickly. And for us, speed is both helpful, both to get results quicker and to address time-sensitive issues, but also speed means we can do more. The quicker we can move cases to resolution, the more capacity that allows us to take on more, even with the same amount of resources. So a lot of these things are designed, as I mentioned, no one of these changes is going to sort of change the game for us or for DLCP or for the public. But as I view them, all of them together really is going to be a resource expander to allow us to do more without having to have more attorneys or more staff.
Makes sense. Okay, so you mentioned that OAG pursues CPPA violations related to violations of tenant and environmental rights. And that's an important point because this law covers so much more than what people may think of as consumer protection. So how will the expanded provisions in this bill help specifically in these types of cases?
That's a great question and a great point, because consumer transactions cover everything. It's everyone, people's everyday life, buying a cup of coffee, paying their rent. In terms of these areas specifically, I can give an example in the landlord-tenant context. One of the changes that both we support, as well as in particular the legal services community has been a big advocate for, is for clarifying who counts as a merchant. And one thing the bill does is it makes very clear that a merchant is covered by the CPPA, even if they're not the one that has a direct contractual relationship with the consumer. So one important example for that is the property management company. They're not the ones who are on the lease with the consumer, but as we've seen time and again, they may be responsible for deception and other CPPA issues. The example you mentioned, third-party utility companies, those sort of middlemen, what we're trying to make clear is that the CPPA covers all bad actors who deceive consumers related to a consumer transaction, even if they're not the ones signing the contract or they're not the ones on the lease.
Great, that's helpful. Did you want to talk any more about environmental rights?
I think I can't think of one specific change that would apply exclusively to environmental rights, but what I can say, the biggest area where we see the CPPA applying to in the environmental context is something we call greenwashing, which is essentially, I guess, to put it charitably, businesses overstating or inflating the environmental impacts of their product or their practices, or in some cases, flat out lying about the impacts that their products will have on the environment. That is something that we've taken action on in the past. We have ongoing, as other states do, climate deception cases against big oil for decades-long cover-ups and misinformation about the impact of their products on the climate. There are other issues that private practitioners that have addressed in greenwashing, including recyclability of products. And so while there's not a specific change here directed toward those cases, all of the sort of tools and ability to go after these sorts of consumer protection cases without undue delays would apply in all contexts, including in the environmental context.
You have piqued my interest regarding the recyclability of products.
Okay.
Could we talk more about how that plays out in court or wherever else you're pursuing it?
Sure. So recyclability, we have not brought a case specifically in that context. We have, well, let me take a big step back. One very important provision of our consumer protection law that is somewhat unique to DC, a couple of other states have it, is what we call public interest or nonprofit standing, which is a provision that allows public interest and nonprofit groups to go into court and seek widespread relief on behalf of their interest group. And we have seen a lot of that very actively brought in this greenwashing context. One example of a case was a case brought by a group called Earth Island against Coca-Cola for essentially greenwashing about recyclability of their plastic products.
Bottles. Yep.
And the theory of that case is that the vast majority of plastic bottles, even the ones that go into the blue containers, don't ultimately get recycled, and that the allegations are that the company had a widespread campaign that misrepresented how recyclable their products actually were and made commitments as to recyclability in the future that they would never be able to meet. Those are the allegations of the case. That case is ongoing, but the defendant, Coca-Cola, sought to dismiss that case in essentially saying that the CPPA doesn't cover these sorts of things because it is the deception is too unrelated to the product itself. They took a very narrow view of the CPPA, and that in order for the CPPA to cover it, the deception has to be about the nature of the product itself. So like lying about its sugar content, for example. That case ended up being dismissed and was appealed to the DC Court of Appeals. And as an amicus, as a friend of the court, our office weighed in because we thought it was very important to reorient the court as to know the CPPA really is meant to be broadly construed to address deception, any deception relating to a transaction that would be important to a consumer, whether it's directly about the ingredients of the product itself or about something else that matters about the product, like recyclability. And so the Court of Appeals that ended up reversing sort of adopted our view, sent it back down. And so that case is now being litigated. And that case is going to have very positive impacts in terms of not just our offices, but also private actors and nonprofit groups' ability to bring those sort of cases in the future where we have the facts to make those sorts of allegations.
Very interesting in the context of some legislation we're considering right now. So thank you for that. Okay, so I want to go through some of the individual provisions that relate to OAG, starting with some of the expanded enforcement provisions. The bill permits the court to require wrongdoers to pay reasonable costs and fees that OAG incurred during an investigation. Can you discuss why this is important?
Sure. So current law already allows for us to recover attorney's fees and costs. The law is not clear as to whether those are just costs during the actual litigation or pre-suit. And taking a step back, the whole reason behind this provision, and I should mention that only applies obviously if we ultimately get a judgment, a court or a jury finding that they did violate the CPPA. And the whole idea behind this is where a bad actor has been found to be violating the CPPA, the public shouldn't be on the hook for all the costs and the time and resources it took to identify that and to resolve it, that the company should be. And the way we think about it, that same principle, it shouldn't matter whether those costs and resources are incurred before the day the suit is filed or after, because as I mentioned, most of our work is happening pre-suit. That's 2/3 of our time probably is before an actual lawsuit is filed. So the majority of our time and effort is just finding out, is there a problem here? And so the idea behind this provision is if we do find out there's a problem and we do convince a court or a jury there's a problem, those fees and costs should be borne by the bad actor and not public funds.
Do you have an approximation of how much we're leaving on the table right now with this not being covered?
No, it's very hard to approximate.
Yeah.
But I think you can sort of get there by seeing the sort of 2/3, 1/3. That's 2/3 of, the salaries and time of a dozen attorneys and other 10 staff that could be. And I should say, in most cases, that's not going to be a sort of separate line item because most cases resolve in settlement.
Mm-hmm.
But it is also something that is going to be encourage quicker and better cooperation by the defendant, because they know if I drag out this, as often the incentive is to drag out an investigation,
They're going to get the bill.
they're going to pay the costs of that.
Yeah. And what about minimum penalties for companies found to have violated the CPPA and OAG actions? Can you discuss why these are necessary?
Yes. So penalties in the broad scheme of the 3 buckets of relief we can get: injunctive relief, change the practices. That's always priority number one. A close second is restitution, money back into consumers' pockets. The third bucket of penalties does fall third within those priorities, but it is also very important because of the fact that we can't go after everything. So this is what we use as a deterrent. And the reason that penalties are so important as a concept is that they are necessary so that violating the CPPA isn't just a cost of business for businesses. Because if a business is deceiving consumers, and if at the end of the day they get caught, which isn't going to be every single business because we can't go after every single business, And then if they get caught, all they have to do is pay back the money that they took.
Mhm.
There's not going to be anything disincentivizing them from just doing it again. And like,
Mhm.
yeah, if I get caught, I'll have to pay. So the
Yeah.
penalties is very important, not just because it in part comes back and helps. A lot of that money is used to make sure we can continue bringing investigations, pays for depositions, pays for experts, but it's also important as a deterrent. And having some floor is also important so that a defendant knows that there's, if you're found liable, you're going to be paying some additional amount in addition to the amount that you've took. And so where these numbers came from, the $500 minimum for the first violation and the $1,000 for subsequent violations, that's essentially in line with other state AG, state consumer protection laws that have minimum penalties. There's no science to that exact number, but we thought it made sense in comparison to the maximum is 5,000 for first violation, 10,000 for subsequent violations. But again, most of our cases don't end in trial. So a lot of this is it creates more deterrence and creates more leverage for us to be able to bring businesses to the table and try to resolve more of these cases quickly.
And how did you determine the minimums of 500 and 1,000?
Really just by looking to other enforcers, other states' consumer protection laws, and also wanting to have, since they're minimum numbers, have them be sort of reasonable figures in comparison to the maximum. That also gives a pretty wide range for, ultimately, at the end of the day, it's the court that determines the penalty. And we want to still give courts discretion to set that penalty on what's appropriate based on the egregiousness of the case, the amount of the harm, the bad faith, how much the conduct was done in bad faith, factors like that courts consider.
I'm also curious about info sharing with law enforcement. So what types of cases do you anticipate this applying to, or has this been applied to in other jurisdictions?
So in the ability to share information with other law enforcement entities is really critical to our work, in part because, I mentioned our docket includes a mix of very hyper-local cases, DC businesses affecting DC residents, but also, in this day and age, a lot of the conduct that is most harmful to DC residents is crossing state lines and is often national, which means it makes sense for us to be able to efficiently coordinate with other AG offices, with other enforcers, so that we can pool our resources. A good example is the Juul case that I mentioned. The Juul, the vaping company that had a variety of bad conduct that sort of targeted its products at minors. That was a case that dozens of other state AGs brought in parallel with us. And it was critical for us to be able to share documents with other state AGs without each of us having to reinvent the wheel. It really saves us a lot of resources. And so what the provision in the bill would do is just enshrine it in law that we are allowed to do that. That is often a fight in litigation where defendants and companies go into court and ask for a court order prohibiting us from doing that sharing, which, again, we don't believe there's any legitimate reason for other than to slow down these investigations and to thwart our ability to cooperate. And then, the other example is, it is not super often, but every once in a while, we're looking at a particular issue, a particular company, and we see something that is very alarming that is not in our wheelhouse. It may be something criminal, maybe something solely happening in another jurisdiction. And we think we should have the ability to alert other law enforcement that is happening without being constrained and being able to share that information.
The bill also explicitly prohibits unlawful transactions under the CPPA. Why is it important to prohibit these explicitly under the CPPA?
So this falls in the bucket of something that we believe current law requires, but that is often a fight with defendants and slows down our cases sometimes by months and requires a number of resources to resolve. So the concept behind it is, so if you look at the CPPA, it prohibits a bunch of categories of deceptive business practices. And then it also includes essentially a laundry list of, if you violate any of these other laws, it is automatically a CPPA violation. And what courts have found is that this is a non-exhaustive list, that in fact, the violation of any DC law, so long as it is in the course of a consumer merchant transaction, is and should be covered by the CPPA. So that all of the CPPA remedies, each of the buckets that I mentioned, that we can go after unlawful conduct that a merchant, to the extent a merchant breaks the law while engaging with the consumer. Some specific examples. One of the claims in Juul was violating specific DC tobacco laws relating to sales for minors and making sure they had adequate age verification. That is something that it was important that that be part of the suit, because that is sort of a core problem that we were aimed at targeting. But Juul made the argument that, well, that specific law isn't on this list, so it shouldn't be permitted. We ultimately won on that issue, but it would save time and resources and provide more clarity to businesses to make it crystal clear in the law that the violation of any DC law in the course of a consumer merchant transaction is covered by the CPPA. We see this a lot with DC health and safety regulations as well, where we're seeing problems with a business being deceptive to consumers while also violating a bunch of health and safety regulations. We saw this in a case we brought against a daycare center that had very serious issues and allegations of sexual misconduct that both included deception, but also they were violating a whole host of health and safety regulations, minimum teacher-student ratios. It was very important that in that case, we have the ability to go after those violations as well.
I am concerned to hear that businesses in the district have threatened retaliation against consumers for filing complaints, and I can only imagine how this may discourage consumers from taking action. It's shocking to hear that the CPPA currently does not protect against retaliation for consumers, and I'm glad to see that in the legislation. But is there really currently no law that prohibits this?
There is a imperfect provision of the CPPA that prohibits harassment.
Mm-hmm.
The problem it is both not clear, and also we think that there are things that fall short of harassment that are retaliation. We have used that provision to address issues. For example, we had a construction fraud case that we brought to trial and won that included the contractor truly verbally harassing and threatening consumers who came forward and worked with our office. And we were able to use that provision to hold him accountable for that conduct. But there was other conduct he engaged in, for example, he literally called up some of our cooperating witnesses' employers, telling them that your employee is making false accusations about my company, trying to get them fired. Things like that we think are clearly retaliatory, and having a clear prohibition on retaliation makes sure that we can go after all of that. You think of, I mentioned a lot of our work is in the landlord-tenant context. That is like critically important that we have retaliation protections. People are especially vulnerable when these are, they have to interact with their landlords on a regular basis. There is always a concern that in those cases that the landlord may take actions to evict, other things that aren't clearly harassment, but are retaliation for cooperating. That's what this is designed to go after.
Makes sense. Okay. Is there flexibility for this provision to cover other types of retaliation?
There is, by its very design. So retaliation is not defined specifically, or a list isn't provided, in part so that courts will have the flexibility to determine what is retaliatory. I mean, it is always going to be a very fact-bound question. So for example, in the landlord-tenant context, a landlord may raise their rents and it may affect someone who may have complained, but it may be across the board, and it may not. It is going to often require specific facts to show to a court or to a jury that this was retaliatory. The example I gave of the construction fraud context, it was very clear it was retaliatory. The person said it basically was trying to get people fired because they complained. He said it was because they complained. But the idea is to have a flexible standard that would apply in all sorts of situations involving retaliation.
Okay. Is there anything else you want to share about the provisions relating to OAG or the importance of this legislation?
I th- I think the one thing I'll just sort of say in a nutshell is I'm more familiar with OAG's processes and procedures and the provisions of this bill that this is designed to bolster. But while DLCP is best positioned to talk about their provisions, we really are very strongly supportive of them having greater teeth to their enforcement because it truly is complementary. Our ability to send things DLCP's way that relate to improper licensing or one-off brick and mortar deception is only as good as their ability to have remedies where they can go quickly with teeth and go after those things. And so I know we've had a very collaborative relationship with DLCP. They're very supportive of OAG's increased authority because they also want to make sure the things they send our way, we can have the ability to go after. And we feel equally about the types of issues we have to refer their way.
Great. Well, thank you very much for your testimony.
Thank you. Appreciate your support.
This will conclude today's public roundtable. The time is 11:02 a.m. and the roundtable is adjourned.